Happy Monday morning. Welcome to our critical COVID updates for employers and foreign workers. I'm going to give it a second to make sure our participants are able to join, and then we will get started. Today, you may hear some noise and doorbell ringing and stuff from the background. I am in trying to maintain social distancing and comply with the CDC recommendations. I'm broadcasting from home, and you may not know this. A couple of weeks ago, my father, who is 81, had a stroke, and so he is with us at home, and he's doing better. He's, thank God, he's doing really well, but he still needs to get occupational and physical therapy. So we may have some, the doorbell ringing and stuff for people coming in. But thank you for joining. And today we want to take not only talk about the COVID updates, but given it is the H-1B season, and wanted to give you some, practical tips on what is needed to make sure that your petition gets approved, talking about court cases and other things. So with that, we will get started. So first, so as I said, we're going to recap from last week, which was, we talked about F1, H-1B, cap selection, small business issues, specialty occupation, employer-employee relationships. And we're going to talk about some recent court cases that is going to be impactful for the upcoming H-1B season. And so a recap from last week. Last week we talked about F1 student updates, what the requirements are for OPT and unlawful presence, and the H-1B cap selection. We also talked about the employment issues. What can you do if you have a termination? And what's the issue with leave? And okay, I've got a couple of questions. And Thanam will make sure that we take care of your issue. Denise, I will get to that, I think, when I start talking about the questions on F1s. So to get started, if you missed last week's webinar and you want to listen to some of the issues in terms of the F1 updates or the H-1B employment and small business issues, then please listen to last week's webcast. And how can you listen to last week's webcast? Well, you can listen to it by going to our YouTube channel, subscribe to we're going to be having continuous updates to talk about various issues regarding immigration. And so we'll be able to address your questions there. And Akash, I will talk about furlough as well. So let's first understand, what are the requirements for an H-1B? So an H-1B, the position has to have a bachelor's degree or higher as a minimum entry into the profession. So for example, even if you have a master's degree, you can't flip burgers at Burger King, because it's not normal for people who are working at Burger King to have a bachelor's degree. The requirement is, common in the industry, or the job is so unique that it can only be performed by someone with a degree. Okay, so the lottery is, the H-1B lottery outcomes, it's already been selected. So I think somebody asked how many actual numbers are advanced degrees, and I'm going to see if we can get an answer to that. How many selected from my team? Selected are advanced degrees. And so I'll see if they can let me know as we are progressing. So, it's got to have a bachelor's degree or equivalent. So how do you prove that? The degree, one of the things is the degree is common in the industry. The job is so unique or complex, because you're focusing on the job duties, that it can only be undertaken by somebody with a degree. The employer normally requires a degree or equivalent for its position. So, or the nature of the degrees are so specialized that knowledge is required with the attainment of a bachelor's degree. So whenever this comes up, typically on a request for evidence, an RFE, after the H-1B is filed, you have to show that it means one of these prongs. What we try to do is we try to meet all 4 prongs. But one thing we always ask the employer at the beginning is, do you normally require a degree? Do all your individuals with that particular job title have a degree? If so, what we can do is we can produce evidence to show that they always require a degree for that particular occupation. So that is, you only need to meet one prong of it if you're able to do that. So how do we do that? We show the payroll. We list all the individuals with the degree, and we submit sometimes their degree, sometimes you don't want to ask people for their degree, or their LinkedIn profile to show that the employer typically requires a degree in the occupation. To show that a degree is common to the industry, you can submit job posts, postings from other companies that are similar in size, similar in occupation, to show that it's common within the industry. And in terms of whether the job is so unique or complex, detailed job duties really help in meeting that requirement. So that's how you prove that a job is a specialty occupation. So the problem with the trend with specialty occupation requests for evidence is when the USCIS is assessing whether someone, whether a particular position is a specialty occupation, they use the DOL's Occupational Outlook Handbook. That's a very antiquated handbook. So it has, it was prepared in the 1990s based on the government occupations in the, especially in IT, for the IT industry. There has been such a change, in terms of what occupations there are in IT. They didn't envision, for example, a user interface, issues, or AI, or robotics, or a number of those things at that time. So the problem is, if it's not one of the occupations that's listed, it gets dumped into this, what I call dump file, called computer all other. And so because everything from a software engineer to a computer architect to a user interface to a number of other things get dumped into that non-specific file, there's no degree requirement for that. So then the USCIS had started issuing RFEs saying, hey, if there's no degree required for that particular occupation, then it can't be a specialty occupation. It's got to be a subspecialty. And we'll talk about some court cases that have changed that. And they also try to make sure that the description is aligned with the SOC code. And the problem is, like I said, because it's antiquated and because it's not specific, you know, a lot of those codes and a lot of those degrees descriptions are not really updated to deal with what we're dealing with now. And then there was the memo on entry-level positions, which was a very ridiculous memo. So they said that for computer analysts, for example, that it can't be a entry-level position because an entry-level position would be something that a person with an associate's degree could complete. So it was only supposed to be specifically for the computer analyst position. But what happened is they started applying it broadly to all other positions. Now, we've been able to successfully argue that by stating, for example, you know, if you're a doctor, when you start practicing, you work under, you know, the supervision of another doctor. When you are a new attorney, I'd have an associate that, you know, has not only had a bachelor's degree, but then a law degree. And, but that associate initially would start working under the supervision of a senior attorney. But that doesn't mean that it's not a specialty occupation. So those are some of the issues that have been coming up on an RFE. Another issue that has been coming up is the employer-employee requirement. So the regulations state that for an H-1B, the petitioner has to be an employer, a US employer. So how do you show that it's a US employer? Well, they have typically outlined that it's got to be a right to control. Does the employer, especially, and this is not an issue when the employee is working at the location where the petitioner is. So if you are, you know, an IBM employee and you are working at IBM, there's no problem. You know, you don't have to show the right to control because you are at the premises. It is typically an issue when it's at a third-party site. So let's say you have a contractor from ABC Inc. working at IBM. Then they want to know, how is ABC Inc. controlling the employee's employment? And you have to show that there's a valid relationship throughout the requirement. And what they mean by that is typically they look for availability of work at the third-party site. So if you have contracts that are shorter in duration, they were only issuing the H-1B for that duration. And there's some court cases that have added some additional, you know, requirements for the USCIS. So these are all, these court cases really are very good for the H-1B season for employers, petitioners to leverage for some of the issues. So the right to control for the duration of the period requested. So that's what I was saying. You have to show that the work is not speculative, but it's anticipated. So the memo outlined what type of evidence, even though the USCIS has been requesting it for a long time, they actually outlined in a memo 2018, you know, that the contracts with specific works and validity dates, itineraries of dates, locations, and services provided, client letters, statement of work, job orders, and service agreements. That doesn't really align with real world, because a lot of times, you know, the statements of work are for 6 months at a time, and it's been renewed. And, you know, the reason why they're 6 months at a time is generally, you know, the end client wants to make sure that they protect their work and not, you know, just in case something happens financially, just in case there's a change in the environment, they're not locked into a contract with the specific vendor. So they'll do it for 6 months at a time, they'll evaluate it, and then they'll extend it. There are some companies that have made that an absolute policy. So even though we have demonstrated that, historically there has been extensions of that work order, the USCIS has only been granting it for that particular period. So that's been very difficult for most clients. There is, let me see, a question. So let me answer that. Oh, it's a very long question. We had an employee who was here on an H-1B. His extension got denied and returned to India. We're planning to apply an L1A visa for him after he completes 1 year in India. In the meantime, if he travels to the US on a business visa, will we be able to apply for his L1 after 1 year and 2 months? Yes. So the question is, an H-1B visa, the individual has gone back to their overseas office, and they want to, because the H-1B was denied, and they want to leverage the ability to bring the H-1B over on an L1A. Now, the requirement is that the two entities have to be related. So it's either a parent subsidiary, affiliate, could be a joint venture in certain circumstances, and the employee worked for the overseas entity for at least 1 year. And so you submit pay stubs to show that the employee was working at the overseas entity for 1 year. So the question is, if they enter the US on a visitor visa, on a business visitor visa, then does that, how does that affect the 1 year requirement? So the issue is, it does not, the period that they spend in the US would not be counted against the 1 year. So they would have to, instead of just a 1 year period, it would be 1 year and exactly how much time they spent in the US. It doesn't interrupt it. But so the 1 year does not have to be, it's cumulative, not consecutive. So it doesn't interrupt that. And indeed, you would be able to apply after they've worked the full 12 months overseas. Another employee of our team traveled on the US on a B1 visa and was due to return back to India on March 20th after completing 5 weeks, but now is stuck due to COVID. Although the business visa allows for a person to stay up to 6 months, as most companies, we don't prefer to keep a person on a business visa over a month. Is there anything we need to worry about or take care of in this situation? Well, what you need to do is make sure that if the I-94 card allows him to stay the full 6 months, then you don't need to worry about anything. He can stay for the validity of what's outlined on the I-94 card. If the I-94 card is going to, the stay is going to expire, what you would want to do is file for a B1 extension prior to the expiration. Because right now there's still travel restrictions and issues with people being able to return home. And so if that's the issue, you can do that. So A, it will not hurt the company to have the employee stay throughout the validity. B, if the I-94 card is going to expire, I would file for an extension. And the other question was, an employee's mother traveled to the US to stay with her son for 6 months. If she can't travel back to India, what can she do? Again, same thing. You file for an extension of the visitor visa and cite the fact that they are unable to travel. My H-1B max out is in mid-June. So is there any way we can further file the H-1B extension to COVID, or do I need to change a status for B1, B2? If yes, how early do we need to file for that? So a couple of things. If your H-1B is maxing out, did you spend any period outside the United States? If you spent any period outside the United States, the 6 years for the H-1B is only calculated by the period you're in the US. So you can, the period you've been outside the United States is called your buyback time. So you can file an extension for your buyback time. Number two, are you in the process of your permanent residence? Because if your I-140 is approved and you can't adjust status because of the backlogs, you can get a 3-year extension on your H-1B. And if your perm or I-140 or together have been pending for more than 1 year, you can get 1-year extensions. So those are some things to think about. But if none of those things apply to you, you can file for a change of status to B1, B2. And I would file that, before the expiration, well before the expiration of your H-1B. Not an H-1B question, but what if you're on a green card and went to India, got stuck and can't come back within the 12 months? Can your office help? I would, I think, when you're able to come back, I would document that. So if you're a green card holder, you can't be outside of the United States for more than 12 months. So if you're unable to come back because of travel restrictions, where does the issue come up? The issue comes up when you present your documents to the CBP. So as long as I think you document to the CBP that you were unable to come back because of restrictions, I think that you should be fine. In addition, if the consulates open up, and they probably will open up by the time you're able to re-enter, then what you can do is you can go to the consulate and outline why the situation required that you could not enter the US. So we're going to talk about some particular court cases and how they're impacting H-1B petitions this year. So one question is, during my H-1B, if I'm outside the US, is it mandatory to run the employer by my payroll? Not if, it depends. Are you outside the United States for pleasure? If you're outside the United States for your own, visiting family and everything else, no, the employer doesn't need to run payroll. There was a case where the H-1B was outside the United States, and they found that the payroll needed to be run because the employee was doing work for the employer. But I would argue a jurisdiction issue. The US has jurisdiction over employees working in the United States. I would say it's outside their jurisdiction to dictate what the employer has to do with employees that are outside the US. So if they're inside the US, it would be a jurisdiction issue. If you were on, he said he was on paternity leave and stuck. So it was a personal leave. So no, the employer does not have to pay your salary. We are trying to fill a position so unique that requires specialized skill set. We came to candidate currently on year 2 of H-1B visa with another company. The candidate decided to withdraw. But how realistic would a transfer be at this time? There's no problem with the transfer. And so, you can apply for, with portability of H-1Bs, you're able to apply for a transfer, and you don't even have to wait for the transfer to be approved. So, what you're able to do is you're able to file, and as long as there's proof that the transfer has been received by the USCIS, the employee can work for you. And we've been having no issues with transfers, so that's not a problem, even through COVID. I have a question regarding LCA filing for an H-1B processing this year. Please let me know how soon we have to file an LCA once our H-1B is picked up in the lottery. Well, I would file as soon as you possibly can, at least for the LCA. And I'll tell you why. That if you file the H-1Bs before, typical processing time for the DOL to adjudicate an LCA is 1 week. If you're a new company and you haven't done it before, it's 10 days. But there have been times where the DOL site has been down. So, that's also a problem that you have to worry about. So you want to make sure that you've got the LCA. You can wait till you have all your other documents till later. And here are some decisions that will actually help in your H-1B processing. So The USCIS denied a case because the petition did not require a degree in a specialty occupation. This is very interesting. Remember how I talked about the OOH and how they look to the OOH? So usually, you know, for some positions, they'll say, like for software engineer, they'll say, you need, the OOH states you need a degree in computer science. I think it's information technology or engineering. It doesn't say specifically what type of engineering. And that makes sense. If you think about it, if you are an IT professional, but you're working in the aeronautical industry, you may need an aeronautical engineering degree with several years of IT experience. So we have in the past argued a number of things. Number one, we've argued that the OOH is antiquated and it doesn't really appropriately outline what the individual's experience is. And secondly, we've said that the regulations state in the specialty, in the specific field, not in the specific degree. So there's a difference between specific field and specific degree, and we've been successful with that. But this particular case, the plaintiff was Inspection Expert Corporation, and they filed a quality engineer position that was selected in the H-1B lottery. And so they had stated that the beneficiary would use his knowledge of computer-aided design, mechanical engineering to develop and design and execute software test plans. So the USCIS, of course, requested evidence on that. And the company submitted an RFE with 250 pages. And this is what I tell employers and beneficiaries now, that when I first started and we'd have an RFE, you know, there would be times where I could call, back then you could call the USCIS, I'd call the person who's reviewing the petition, they'd say, hey, can you fax me this one document? And we'd be able to fax it in. Our RFEs now are about this thick. They are, and so clearly this one was similar to what we had. And they included evidence of a professor in the Department of Design and Innovation at the University of Buffalo stating that it was a specialty occupation. And so the USCIS denied the petition because it didn't require a specific degree in a specific specialty. And, you know, the judge would not have that. And so what the judge stated was, and I wanted to read it directly, is that that the general degree in engineering, or one of its subspecialties, such, you know, the USCIS stated in the denial that it was not closely related to mechanical engineering. And the judge noted that that it doesn't have to be in a subspecialty. That in fact, they found that the USCIS used convoluted, nearly indecipherable rationale to define the word degree to mean not just a degree, but a degree in a specific specialty. Based on that rationale, the agency would find a position to be filled by someone with a mechanical engineering or electrical engineering degree. The USCIS would say the position is not a specialty occupation. So the court held that the USCIS was interpreting that too narrowly. So if the petition requires a range of engineering degrees, it can still qualify as a specialty occupation, which is really critical, because you often have that issue with software engineers that, you know, they may have an electrical engineering degree or mechanical engineering degree, but years of experience working on IT. So now we can use that case for an RFE to show that it doesn't have to be closely related to, in this particular instance, there was a denial of a degree for a restaurant manager. And it'd been approved twice. And they said, hospitality management is, you know, restaurant manager is not one that is typically a bachelor's degree. And they had cited to, in deciding that it was should be an H-1B position, they cited to the type of duties that the individual was doing. And this was an extension, so it was kind of a little crazy that they would, issue that because of previous extensions. And they mentioned that as well, that, it was previously approved. And the types of duties the individual was doing was financial forecasting, management of employees, HR, and that, it should have been considered a bachelor's degree based on the duties. So again, for cases going forward during this H-1B cap season, this is a very good case to reference. Oops. So in this, a computer systems analyst was denied because the OOH, again, the reference that the USCIS uses said normally and not most. So, we have in the past argued that, when they use the word common, that it does mean that the majority of the time it should be interpreted as a bachelor's degree. But, now we have that in case format that states that even if so this has been a great attack on the USCIS adjudications when it comes to denying petitions based on the OOH, which, like I said, is antiquated. So the court found that that if the OOH says it's common, that it should be interpreted as normally requires a bachelor's degree, and they can't deny it just based on that. And here's a question. I have a situation where my I-140 was filed on 4/16, but my H-1B is maxing out approaching May 25th. Do I need to go back to India and wait for the I-140 to be approved and my petition is approved for consular processing? Can I stay in the US if the lockdown is extended and I can't fly back to India? You may be able to do do you have any buyback time? If you have, like I said, there are two ways to extend an H-1B. You can extend it, for periods that you've spent outside the United States while you were in H-1B status. So if you have any time on that, you can use that to extend your H-1B beyond the 6 years, because you're only required to, only the periods that you're in the United States count against the H-1B 6 years. So if you have that, you can use that. Otherwise, yes, I would suggest that you go back if that's not the case, and then have them file an extension, and then you can return to the US. On this one particular case, they spoke to the itinerary regulation and the contracts, on itineraries and memos. And, the issue is when you file for an H-1B, you can't file because of the anti-benching provisions, which means that the employer has to pay the employee for the period requested. The USCIS, has said that the employment has to be anticipated, not speculative. And that's what we've argued, that there is a difference between anticipated and speculative. But what they've used is that memo on the itinerary and contracts requirement to issue very short periods of approvals on H-1Bs, sometimes for a day, which is ridiculous. So as long as you can show that that there is work, like, for example, the employer has a number of different contracts, and they're able to demonstrate that, they have been paying their employees. This is how much they have on payroll. This is how much revenue they're getting from all their other projects. Then the mere fact that that the contract is for a shorter period, they can't issue it for less than 3 years unless, because of this case, the USCIS outlines the reason why they're issuing a shorter H-1B, which is great because you've had clients who've had H-1Bs approved for like 3 months. And with the ridiculous USCIS fees, that just increases the cost of the process. So an update on what's been happening. As we said, premium processing has been suspended without further notice. We hope that that changes soon. Receipt notice generation they have outlined is going to be delayed, especially for the CAP filings until May 1st, and filings are stamped on the actual arrival date. The receipt notice will correspond with the actual arrival date. What I would suggest to you is when they do receive a H-1B petition or any petition, they stamp the checks. So once the checks have cleared, if you get a copy of the check, your receipt number will be on back of the check. So that's just a good tip from me to you. There's no extension on the filing window, and they won't allow for any inquiries until the receipt notice are issued. And there's going to be a general delay of processing until, you know, there are more resources at the USCIS office. So I have another question. Let's see. I had an H-1B now. I'm in the process of permanent residency. My EAD was approved since the middle of November last year. Is a COVID affecting the timing of the green card? Yes, COVID is affecting the timing of all processing, especially, you know, anything that requires an interview, or because they've, you know, application centers and local centers, they've stopped actually having in-person interviews. So if your H-1B was, I mean, if your permanent residence was in the process and you've been issued a EAD, but you have not been interviewed, that's going to delay processing, whether it's naturalization, whether it's permanent residence, whether it's biometrics, a number of other things. So, you know, we wanted to share with you a little bit how we've been successful. As you can see that our approval rating is much higher than the national average, because even before these court cases came out, we were arguing some of the things that the judges pointed out. So if you have any RFE issues or any questions, please let me know. And as I stated, we'll be giving these seminars every week. Please visit our YouTube page and subscribe. Like us on social media. We'd really appreciate it. Email us with any questions that you may think about after the end of the seminar. And as always, have a great week. This is Lakshmi Challa. Oh, I have Steve Rao raised his hand. So let me, I've got 2 participants that have raised their hand. 3 participants have raised their hand. Okay. Let me see. Okay, Steve, I'll let you, did you have a question? Oh, sorry.
Can you hear me?
Hi, Steve.
Hi, I'll be real quick. I know I got the tail.
Are you able to?
Yeah, can you hear me?
Let me see.
It's okay, I can just email my
Are you
question.
able to talk?
Yeah, I can hear you. Can you hear
Steve?
me?
We can't hear you.
Okay, hold on.
Oh, no. Okay, hold on. Yeah, you're unmuted.
Yeah, I don't know. I can hear you, but you can't hear me.
But I can't hear you.
Oh, it's okay. I'll just email my question. Thank you.
Kara, are you online? Okay, there's some questions that have come up. Yes, you can ask questions. I'm trying to figure out how to do this. If Kara is online, see if she can unmute the people so they can. One of the questions is, oh, you could hear Steve talking. I don't know, for some reason I couldn't hear Steve talking.
Can you hear me? Hello? Can you hear me?
Okay, let me increase the volume on my laptop. Oops.
Hello?
Now I can hear you.
Can you hear me?
Yeah, I can hear you now.
Oh, well, I'll be really brief. I know it's at the tail end. Well, thank you for these updates. They've been very helpful. And, you know, we have so many H-1Bs and more so carry the triangle. So I guess, you know, my question is, sometimes we get caught with situations of like recently I've been seeing a lot of situations where the families could potentially be separated. We've got a couple of individuals where the parents had to go back because they couldn't get their H-1B extended, but the children were born here. You know, and so they're separated. And that's one issue where I might forward them to your firm. The other one is the sense of economic nationalism that we're seeing today. And, you know, the concern of, well, jobs are being, you know, lost because of the meltdown, 22 million unemployed, 500,000 unemployed in North Carolina. And so, you know, a pushback against H-1B, right? So
right, and but the problem is what they're not understanding is it's not a zero-sum game, right? So it's not a job that's issued to an H-1B is lost to a U.S. worker, because that doesn't take into consideration the skill sets. And I think that's what's
okay, maybe that's the message
highlighted is, and I think we'll see that. I think we'll see that, you know, they had curtailed filing of H-2Bs for the agricultural industry and, you know, the summer jobs. And I think we're going to see, I know that in North Carolina, for example, a few years ago, there was 1,000 agri jobs open. And when anyone goes to unemployment, they're referred to agri jobs to apply. Only 10 U.S. workers applied, only 7 stayed. So I think we will see down the line that, you know, they will figure out that, you know,
whatever we can, this has been so helpful. I'll be putting these in my newsletters. And I think for me, I'll just let you go. But I mean, for me, it was on the radio just a few days ago and someone called in and I actually did a decent job retorting, you know, talking about, you know, John Chambers was here a few months ago and he said that in order to counter the 40% of jobs we automate, we can create 15 million new jobs and entrepreneurial jobs. And so I think we can have both. We can have the H-1B extensions or H-1B, you know, citizens providing value in the areas where we have shortages.
right.
And I think that gets conversation, right?
And in fact, it shows that for each H-1B position, there are a number of U.S. jobs that are created, you know, and this is what I tell people. I said, you know, if there's a need, if you don't have a .NET individual here in the U.S. and the company needs .NET specialists, so what's going to happen is if we restrict immigration so they can't come here, they're going to Canada. There are companies, and I was on a panel with one such company, Code, that is actually bringing people into Canada to, you know, because of the difficulties we're having with immigration here in the U.S. So what happens is those H-1B workers are getting paid. They're getting paid in Canada, so they're not paying U.S. taxes. They're not buying houses here. They're not consumers. So H-1Bs are not just salaried individuals, but they are consumers and they contribute to our economy as well.
Okay, well, I really appreciate that. And I just want to throw that comment out there. Thanks for all that you do. And hopefully I'll See you
Thank you,
soon.
Steve. And for those you don't know, Steve Rao is in Morrisville, Virginia, the mayor pro tem.
Yeah, well,
And
yeah,
first
I'm not pro temp.
elected individual of Indian ancestry.
Yes, thank you. Well, listen, virtual hugs from us to you all, and thank you so much, and I look forward to joining next week.
Thank you, Steve, for tuning in. I've got another hand raised. Yes, sir. Hi.
Hello. Hi. So I've logged in from my husband's credentials. So right now I'm on H-1B and I'm on my maternity leave, and due to COVID-19, my position got impacted. And right now I am in India, I mean, because I was on my leave. And so my employer told me once I come back, because I'm already on leave, they said they can put me on a furlough for a particular time until I come back. Then
Right.
after 2 weeks of regular payment with the salary, they are going to terminate my job. So is it a valid scenario? Because I think the H-1B employees cannot be put on furlough, right?
Oh, when they're in the United States. Now, you departed the country for your own personal benefit. So, and you're, if you're not working for them there and you're not doing work, some people send employees overseas to do work in their countries there. But if that's not the reason, then yes, they can furlough you and they can terminate you while you're overseas. As long as it's consistent with how they're applying that policy to their US citizens. Hi, I'm on an H-1B, but I lost my job to COVID. I was working for an airline as a contractor through my employer. I know I have 60-day grace period to get another client or another full-time job. But what are my options if I'm not able to secure a job at that time? So we covered the issue of furlough in both our first, the 60-day grace period in both our first webinar and our second. So I would tell you to actually go to YouTube and subscribe to Cello Law Group and listen to the first two. But generally speaking, there is a risk when you take the 60-day grace period. Notwithstanding that, that's what you got. So you can either do that, leverage that, or change to another status, either an F1 or a B1, or you can change to that during your 60-day grace period time. Now, as we said, the risk of the 60-day grace period is it's discretionary. So the USCIS, when they're adjudicating your petition, has the ability to opine whether they want to grant the grace period or not. So that's the risk in doing that. But please take a listen to that. We've got materials on our website that would answer that in greater detail. If any of you, if I haven't answered any of your questions that you have, please email us at info@cellolaw.com. Listen to our weekly updates. I thank you all. Have a safe week, and I hope all of you are staying safe, social distancing, and I look forward to talking to you again next Monday, same time, same place. Take care. Thanks.